Happy Holi to everyone and welcome to my YouTube channel. Today we will be discussing about Companies Act 2013. We have discussed in the beginning that this will be one of the important part of this YouTube channel when we will discuss about Companies Act and various sections about Companies Act. Uh, Before we go into different sections, different concepts of Companies Act, let us discuss about structure of Companies Act 2013, which is very, very important because 2013 Act came as a completely new act after 1956 Act. So 56 years of old act, and now in 2013 they have completely modified the act to have different thought process of disclosures rather than taking approvals. So there was a different thought process behind this particular act. So before we deal with different concepts in Companies Act, let's understand what how Companies Act should be read, how which are the important parts of Companies Act, and different regulations which one has to follow for understanding the Companies Act. So the first and foremost first and foremost document which one should read is Companies Act 2013, which is the Bare Act. And this particular act has been passed by Parliament. Both the houses of Parliament got the assent of President, and then it was released in the official gazette. So this is the basic document. It is binding on all the companies. So we'll definitely discuss about to whom this Companies Act 2013 is applicable in the applicability clause of Companies Act. Then there are rules. The rules are issued by the Ministry of Corporate Affairs, but the rules are issued as per the Companies Act 2013. In more than 400 places in Companies Act 2013, there are mention about as may be prescribed. So wherever there is a mention about as may be prescribed, the prescription authority has been given to the Ministry of Corporate Affairs, and they have come out with different rules in respect of incorporation, in respect of allotment, in respect of deposits, so on and so forth. So for every chapter, there will be few sections, and there will be rules as per for that particular section. So one has to understand that there has to be a mother section which will give authority to the Ministry of Corporate Affairs to release such rules, and if that authority is present, then these rules are equally binding on all the corporates and all the companies. So we'll have a look at different rules when we discuss about different concepts in further videos. Then there are forms which are required to be filed with the ministry, and they have to be filed through the website of the ministry, and they are also equally binding on the companies. So while interpreting, we need to understand that Companies Act and rules are at par if there is a mention about as may be prescribed in the mother section. So they will act as equal, and stricter of the two or the latest of the two will prevail. So in case of any dilemma between what to follow, you have to follow the stricter one or you will have to follow the latest one. So these are the important aspects of interpreting what is Companies Act and what are rules and forms. Then there are notifications. So as per section 462, ministry can initiate issuing of notification. These notifications are issued as per section 462, and they are also having a binding effect because they can give exemption, they can give clarification. So notifications are issued by following the process given under section 462. Then there is one concept which is a unique concept for this particular act, is removal of difficulty order. So as per section 470 of Companies Act, any difficulty can be removed by Ministry of Corporate Affairs, but the time limit for that was 5 years from the commencement of section 1, and section 1 commenced on I think 29th August 2013. So that time limit has lapsed now, so no new orders will be issued by the ministry under this particular section 470. There are circulars and clarifications issued by the ministry, but these are actually nothing but intra-departmental communication. So ministry communicates it with regional directors, registrar of companies. These are the authorities under Companies Act, and they are binding on all the regulators, and every stakeholder can take benefit of such circulars and clarifications. So it is not binding per se on each of the stakeholder, but they can take benefit of it. It is nothing but an internal communication between ministry and their offices. Then there is a website of the ministry. So it is www.mca.gov.in. In the meantime, they are into the process of converting the website from version 2 to version 3. So it is artificial intelligence based website, and all the forms which were earlier filed through PDF form will be now filed through a e-form, so which is a globally acceptable practice. So there is some there are a few issues in understanding and filing, and some technical issues there in migrating from version 2 to version 3, and the process is going on. So it's a transition phase. It will be over very soon, and we'll have a very smooth, globally recognized and globally acceptable website of the Ministry of Corporate Affairs, through which we company secretaries do their work. So that is a very, very important website to understand and remember. Then all these acts, notifications, circulars can be found out on two important links. One is icsi.edu, wherein you can find a ebook which has been developed by the Institute of Company Secretaries of India, or you can check the ebook on mca.gov.in also. So from there you will find a section, and on if you click on as may be prescribed, it will travel you to the circulars or notifications issued. So that's a very good document which you can keep it for understanding and reading the Companies Act. So now let's start the important point about applicability of Companies Act 2013. So Companies Act 2013, all rules, notifications issued, forms, the circulars, everything is applicable only for companies. Number one, the companies are those companies who have been incorporated under Companies Act 2013 or any other previous law. So there are 1956 Act, even the earlier acts which govern Companies Act. So for all those acts, if the company is incorporated under any of these acts, the Companies Act 2013 is applicable, even though there is a saving provision under section 465 which saves certain companies from applicability of 2013, certain sections, but primarily all companies are required to follow Companies Act 2013. Then it specifically says foreign companies, those companies who have their liaison office or branch office in India, the Companies Act is specifically applicable to them. Then insurance companies, banking companies, companies governed under Electricity Act, companies governed by Special Act, all these companies are governed by Companies Act 2013. We will in the next video we will discuss about different types of companies, which will include Nidhi companies, producer companies, holding company, associate company, private company, public company, and other types of companies which are there in the Companies Act. Let me tell you that LLP, the Limited Liability Partnership Firm, is not covered under Companies Act 2013. But LLP Act has a provision that by notification, Ministry can state that particular sections of Companies Act 2013 would be made applicable to all the LLPs. So LLPs will also come under Companies Act after the when you go through the notification issued by the ministry under LLP Act. Then there is a concept called as body corporate. So body corporate has been defined in Companies Act 2013. It is corporates registered under usually foreign act or limited liability partnership firms. They are bodies incorporated. So as a principle, one must understand that all companies are body corporates, but all body corporates are not companies. So this is the basic principle that one should understand. So whenever while reading Companies Act you come across company, you should treat it as Indian company unless the explanation specifically states. But otherwise, whenever there is a concept called as corporate, you can include foreign body corporate or LLP or a company. So all three will be included in body corporate. Any society form under any cooperative law is not covered in the concept of body corporate. So that also we need to understand. It's an exemption given to the definition of body corporate. There is also one concept called as person, even though it is not defined in Companies Act, but many of the places person has been used. For example, section 186 and at many places. So if it is not defined in Companies Act, you will have to go to the General Clauses Act. General Clauses Act specifically defines persons, and it includes individuals, partnership firms, HUF, trust, joint ventures, body of individuals, etc. So all these are included in Companies Act, even though Companies Act is not applicable to them, but these terms have been used. So we'll have to be very confident about interpretation of these three concepts. And once we are aware that to whom Companies Act is applicable, then it is very easy for us to interpret the Companies Act 2013. So thank you very much. If you have any questions on this, you can post it in the comments, and definitely we'll try to solve all the questions. Thank you very much. Thanks a lot.